Good morning, everyone. My name is Courtney Nichols, and I'm one of the co-leaders of Plunkett Cooney's Labor and Employment Practice Group. It's my pleasure to serve as a coordinator and a presenter for today's program. The program is titled Delta Variant Update. Our goal today is to provide you with sort of a global update regarding COVID-19 in the workplace, and in particular, in response to the comments made by President Biden on September 9th that I'm sure you all are aware of and are concerned about, working in human resources and trying to employ individuals during this, everybody's favorite word, unprecedented pandemic. I am joined today by two of my colleagues. We frequently present together. Their names and faces I'm sure you have all seen and heard before. Laura Dinan of our Petoskey office and Claudia Orr of our Detroit office. Before we get started, I do want to provide you with some background about us and about Plunkett Cooney. Our firm is based in Southeast Michigan. It's one of the Midwest's oldest and largest law firms. We have approximately 150 attorneys as of now. We have offices all throughout the state of Michigan, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Our employment law practice group in particular includes 20 attorneys who work in the areas of traditional labor law, human resources consulting, employment litigation, and workers' compensation. Now, a little bit of background about the attorneys that are presenting today. Laura Dinan has over 30 years of experience advising employers. She has built a successful practice representing public and private sector employers of all sizes throughout Northern Michigan. Laura's expertise includes traditional labor and all types of employment law matters. She's a past president and currently the secretary of the board of directors for the Northern Michigan Society Human Resource Directors. An attorney in the firm's Detroit office, Claudia Orr, exclusively represents and advises employers in management and employment and labor law matters. Claudia's clients include Fortune 500 companies, local governments, Tier 1 automotive suppliers, nationwide distributors, numerous nonprofit agencies, and it goes on and on and on. She has extensive litigation and appellate experience and regularly practices before state and federal courts as an advocate. As it relates to me, I've been working in employment law nearly exclusively for over a decade now. I exclusively defend employers in litigation and provide human resources consulting and advice to my clients on all aspects of employment law, including pre-litigation compliance with the ADA, FMLA, FLSA, and all of the laws that we're now dealing with in the midst of this pandemic. With that said, we just have a few final housekeeping notes. So today we're using Zoom as opposed to our GoToWebinar platform. So on Zoom, there's a chat function, and we encourage our attendees today to ask questions in the chat function. I am going to be moderating the discussion. So if we have a moment and something comes up, I might chime in, but for most questions, I'm probably going to wait until the end of the program where we have built-in time for a Q&A session. At the end of the program, if you'd rather ask your question on Zoom, or even if you have your camera off, just chime in verbally, then you can raise your hand using the Zoom features, and I will call on you and direct your question accordingly. With that said, I want to thank you all for taking the time to visit us today and to spend this next hour with us talking about what we're all dealing with in the human resources and employment law world. So today's program is going to feature a discussion of the COVID-19 initiatives, right? This is the topic of the day. This is the thing that people are trying to figure out, where are we going and what does this mean? So Claudia is going to get us started talking about some of the federal mandates and the various requirements that might not be as highly publicized as the large employer mandate. Then Laura is going to take over and talk about updates to the CDC guidance, updates to the MDHHS guidance, your general COVID-19 rules to watch for outside of some of the things that have grabbed all of the headlines in terms of the mandates. Then we're going to finish talking about what's on the horizon with the 100+ employee vaccination mandate. And like I mentioned, we are going to have a Q&A session. So please make sure to stick with us through the end, and we will try to answer as many of your questions as we possibly can. So with that said, I'm going to mute myself and hand it over to Claudia to start talking about our initiatives.
You're going to recall that on September 9, there was a much anticipated announcement by President Biden concerning his initiatives to slow the pandemic. And it generally involved masks, vaccination, testing, and financial support. The next day, the employment attorneys at Plunkett Cooney all received a lot of calls. Some asking, what do we do now? Well, the long and short is that you can expect it's going to take some time to implement some of the initiatives, longer than others. But more importantly, there's going to be challenges to the initiatives along the way, especially to the vaccine mandate. That's for workplaces having 100 or more employees. We expect that there's going to be lawsuits filed challenging this mandate, most likely in a federal district court down in Texas, because that's where all the conservatives file lawsuits to challenge liberal or Democrat initiatives. So it's going to take a while. First, OSHA will have to promulgate the rule. So this could actually take months. What is clear is that the White House looked at each federal department and agency to determine whether any of them had any power that could be exercised to mandate vaccines and masks. So as I cover the vaccine mandates, you're going to see which departments and agencies are being involved. So let's break it down. On September 9, to begin with, President Biden signed Executive Order number 14043, which required all federal employees to be vaccinated. Testing would no longer be an option. President Biden's executive order only applies to the executive branch employees because of the separation of powers. So in other words, it excludes employees in Congress and the Supreme Court. And the bulk of the federal employees are actually in the executive branch. So it's going to include all the federal departments and agencies and the military. The only exception will be if the employee qualifies for a medical or religious exemption. Medical is pretty straightforward, and many of you have dealt with this in the past with flu vaccinations. It will require a note from the doctor. The religious exemption is a bit trickier, and it need not involve any federal religion or church. The employee just needs to notify you of a sincerely held religious belief. If you need help preparing a form that may help limit some abuse, contact us, we can help you. But basically, you may get back some things that say, I believe that there might be a higher power that controls the destiny of the universe, and that by getting a vaccination, it will anger whatever higher power that is and may cause my doom or something like that. So contact us if you need some help to limit some of the abuse. The press secretary suggested the deadline will be in about 75 days, or the employees will start facing progressive discipline. The White House guidance actually says that it's going to be by November 22nd. Next slide. Also on September 9, President Biden signed an Executive Order 14042 requiring all federal contractors to get vaccinated. This mandate applies to new contracts and extensions or renewals of other contracts on or about October 15. This doesn't, however, apply to grants or to the recipients of grants. This is an important point for many nonprofits. The distinction is basically, in a nutshell, whether your agency or company provides good or services directly to the federal government, like it's paper clips, putting up a building for a new federal building, things like that, or whether you provide services instead of the federal government. In other words, if you weren't providing the medical care, then someone else, then the federal government would need to do that. So if you're a grant recipient, you don't have to worry about that. There are exceptions to this executive order, so it doesn't apply to contracts with Indian tribes, to smaller contracts, to work performed outside of the United States, or to subcontractors that only supply products to the federal government. So this next mandate is very important to many of my nonprofits and medical practices. And it applies to all participants of the Medicare and Medicaid programs. If you provide services that are paid for by Medicare or Medicaid, this will apply to you. Significantly, the prior mandates I discussed were achieved by executive order, but this is our first one we're going to discuss that is covered through an agency of the government. This vaccine mandate is by the Centers for Medicare and Medicaid Services, or CMS as it's called. And it's going to include hospitals, nursing homes, dialysis facilities, ambulatory care settings, and home health care services, among others. It's very extensive. And this will be as a condition for those employers, those entities, to continue to participate in the Medicare and Medicaid programs. It's going to apply to all clinical staff and individuals providing services under these arrangements. It's going to apply to the volunteers that are in your workplace, and even to the staff who are not involved in direct patient care, resident or client care. It is very broad. Please don't forget, if you have a union, you still need to meet with the union, even though this is a mandate and you're going to have to implement this, but you need to meet with the union to discuss the impact on the union employees. So talk to your Plunkett Cooney attorney about this issue if you need some assistance with your unions. The next mandate is, the next mandates are accomplished through various federal departments, and it's mandates for teachers and staffs. To begin with, the U.S. Department of Health and Human Services, which is part of the Administration for Children and Families, for the Head Start and Early Head Start programs. The goal is to have fully in-person programs and to keep all the centers open. It's virtually impossible to have early Head Start program run virtually, since you'd be taking care of infants or very young toddlers. So you can't really do that virtually. And as to the toddlers, the pre-head or the Head Start program, their attention span is about that of a gnat. So, they really want to keep these centers open because a lot of them too provide the child care services for workers. So therefore, all staff and certain contractors must be fully vaccinated by January 2022. By that, it means 14 days after the second Pfizer or Moderna shots, or after the J&J single shot. I suggest that you have earlier deadlines and tell employees who don't comply with those deadlines that they will be deemed to have abandoned their jobs. Voluntary resignations, this will probably help you out with unemployment. The earlier deadlines will also allow you to make staffing plans over your winter break. If you wait until January 1 to find out that your employees have not participated and gotten their shots, it'll be too late to have all your classrooms staffed. The next mandate is the Department of Defense, which it hasn't yet, but will issue the mandate for the 160 K through 12 programs for students of military families across the US and overseas. And finally, the Department of Interior, Bureau of Indian Education will require vaccinations for all the employees of the 53 schools that they administer on and off tribal lands. So between the Head Start, Early Head Start, military schools, and schools on and off tribal lands, these will actually catch up. These serve 1 million children, many who aren't even eligible for vaccinations, but it's going to require approximately 300,000 teachers and staff who will be subject to the mandate. You can see that the goal of the administration is really to get as many people vaccinated across the country as possible so you'll have herd immunity. The last exemption that will be discussed, the 100 employee workplace mandate, will be discussed later on in our webinar. But for now, I am passing it off to Laura Dinan, who will cover some of the other pandemic initiatives and updates.
Thanks, Claudia. Can you guys hear me? Hopefully.
Yes, you're good, Laura.
Okay. So the American Rescue Plan made $130 billion available to support schools, and HHS provided another $10 billion for COVID testing at schools. The Department of Education plans to make additional funds available to assist schools and school districts in states where the governors or local leaders are threatening or actually withholding funding. And so they can continue to function. The state of Florida In particular, the governor has threatened that he's going to stop paying school superintendents or principals who enforce mask mandates. And so the Department of Education is going to step in and allow them to use American Rescue Plan funds to continue operating safely and enforcing mandates in areas where the political leaders have indicated they're going to cut education funding. The Department of Education has also been asked to investigate those activities in states where they prohibit mask mandates, and they have active investigations already ongoing in Iowa, Oklahoma, South Carolina, Tennessee, and Utah. So we don't have to worry about that in Michigan right now, but they're aggressively going to try to keep kids in school in person and prevent spread of the disease as best as possible through mask mandates. Next slide, please. So currently, Michigan has recommendations. There are no orders requiring limitations on large venues and other activities, but the recommendation in Michigan for events being held in large venues is if you're not fully vaccinated, you should wear masks while in crowded spaces, outdoors, practice your social distancing. It's recommended that if you go to a large venue with a group of people that you stay with your cohort. They're using this in the schools and they want you to use it as best you can. So if you go to a wedding or something, hopefully you can be seated with the people that you regularly interact with and stay within your group, and that groups can be separated 6 feet apart. This is more practical in some settings than others, but it does help prevent the spread of the disease. They also recommend that food and beverages only be consumed while people are seated in designated areas and in groups no larger than 6, and ideally, these groups, again, are your cohort or the people that you regularly interact with. They also recommend individuals self-screening before attending large events, using sanitizer and contactless practices wherever possible. Have your tickets on your phone or printed out on paper. They recommend anyone that's not fully vaccinated get tested 1 to 3 days before attending an event in a large venue. And obviously, if you test positive or have symptoms, don't show up. And President Biden is asking entertainment venues to require that their patrons be vaccinated or show a negative test for entry. I have not heard of that happening yet, but it may be coming. So the CDC guidance.
Sorry, Laura, I was just going to chime in to say it's not happening in Petoskey, but there's some venues down here in Southeast Michigan that have started doing that. I believe the Royal Music Theater. I'm sure some of our attendees know, but some venues have started doing that down by us.
That's awesome. So that'll probably be coming our way eventually. We don't actually have that many large venues, so I probably should have qualified that. So the CDC guidance on large venues is similar. It advises people to stay home if they're sick or symptomatic. They recommend screening of all attendees, either, actually they recommend taking temperature checks. That's just not practical, but if there's a way to screen attendees, if you're hosting something at a large venue, by asking if they're symptomatic, even if you put a sign out reminding people don't come. Someone just popped up in the chat and indicated that DTE also required proof of vaccination or a negative test for a concert on Tuesday. So it is spreading down. The venues down there are actively trying to screen people out. So they also, the CDC recommends requiring all attendees and staff to wear masks except small children under the age of 2, or if people are medically unable to wear them, to require good hygiene of their staff, including lots of training and giving lots of supplies and opportunities, hand washing areas, sanitizer areas, and cleaning and disinfecting regularly in these large venues. There's also a lot of information out there through OSHA on proper ventilation for indoor events, both in office settings, small settings, manufacturing settings, but also for large venues. And the CDC guidance is that these venues need to look at their ventilation and provide good ventilation for indoor events, keeping doors and windows open to the extent possible, and following the OSHA recommendations. They also recommend revisiting your water systems to make sure that they're safe from Legionnaire's disease. Apparently, one of the major causes of it is when drinking fountains are reopened and not flushed out or sanitized properly, people can contact Legionnaire's disease from those. They recommend modifying the layout of events to provide physical distancing. Again, at a wedding or something, you can spread the tables out. If you're in a concert venue, it's probably a lot harder, but to the extent that seating can be laid out, they request that people do that. They also recommend providing physical guides to direct traffic flow and separate people. You know, entrance only, exit only, follow the arrows on the ground, stand in line 6 feet from the group ahead of you and the group behind you. And again, limiting food and beverage to certain specified areas, making ordering and pickup contactless. And the reason for limiting food and beverages to certain areas, both at state recommendation and CDC recommendation, is because that's an activity where you have to take your masks off, and it is one of the most likely places where the disease can be spread easily. So on testing availability, people are concerned about this because the White House is expanding the need for testing so broadly, so quickly, that people aren't ready for it. And the White House tried to address this before the press conference, and they announced that they're expanding the number of retail pharmacy testing sites where you can go and get tested for free to 10,000 different pharmacies across the country. They also made a deal with Walmart, Amazon, and Kroger, and they have agreed to sell the rapid testing kits for the next 3 months for cost. And that is a 35% reduction in the price that you would have paid at those entities to get a rapid test kit or rapid test. And now for the next 3 months, you'll just pay the actual cost. Medicaid has been ordered to cover home testing for free for any Medicaid beneficiary. And the government is also going to use the Defense Production Act to greatly increase the production of both testing and PPE to ensure that there are adequate supplies to meet the increased demand for tests for across the board, across the country. So, federal property and interstate transportation, you probably heard about this and certainly experienced it if you've done any traveling, but Executive Order 13998 covers both domestic and international travel. It requires people to wear masks in and on airports, aircraft, trains, ferries, maritime vessels, buses, any form of public transportation, or regularly continuing shared ride surface transportation services that are open to the general public. And the fines have been doubled for violations of these mask mandates, particularly in response to the pushback that the airlines are receiving. They felt they had to put some more teeth in the requirement. In Executive Order 14003, which protects the federal workforce, requires masks, social distancing, and other safety measures in by all persons that go in federal buildings or on federal lands, which includes federal employees and federal contractors. So most of you are probably familiar with the American Rescue Plan tax credits at this point in time. They you were required to give the leave, and you could take advantage of them up through December 30th of 2020. They, under the ARP, they were extended to covered leaves between April 1st, 2021 and September 30th, 2021, which is about 2 weeks from now. So at that point, any employer who wanted to give their employees paid time off and take advantage of the tax credits could do so. It was not the employee choice, it was the employer choice. So if you had employees who had to stay home for COVID-related reasons in that time frame, if you paid them, you can take advantage of the tax credits. If you chose not to pay them and had them take it as unpaid time, obviously you can't get the tax credits, but it was your choice. We haven't heard anything yet, but you may hear in the coming couple of weeks that this has been extended. President Biden is very, very adamant about trying to do everything to, on the one hand, protect people and keep them out of the general public if they're sick, but also keep the economy moving. And so this would be one of those tools that he could use to do that, and we may see that coming, but there's no news yet about that. So the latest Center for Disease Control guidance came out July 27th, 2021. It has recommendations for fully vaccinated people that include wearing a mask in public indoor settings if you live in an area of substantial or high transmission, which currently the entire state of Michigan is considered to have substantial or high transmission. So even if you're fully vaccinated, it's recommended that you wear a mask in public indoor settings, that you choose to wear a mask regardless of the transmission level if you are personally at risk or you live with people who are at risk or are not fully vaccinated in your household. It's also recommended, even if you're fully vaccinated, that you get tested 3 to 5 days if you are exposed to a known, suspected, or confirmed COVID-19 case, and that you wear a mask indoors for 14 days after that exposure or until you get a negative test result. So if you are fully vaccinated, get exposed, you're supposed to get tested, and to wear a mask, but you do not have to quarantine any longer unless you start having symptoms or get tested and you're positive. The current CDC guidance for unvaccinated persons is number 1, get vaccinated. If you don't do that, properly wear face coverings over your nose and mouth. There's very explicit instructions on what proper wearing is, and they can be found on the CDC site. If you're working outdoors, CDC says you can opt not to wear a face covering unless you work closely with others. They also recommend that you stay far enough away from other people so you don't breathe in particles from them, generally at least 6 feet, which is 2 arm lengths from others. They also encourage people who are unvaccinated to ask their employer about flex schedules, remote work, taking meetings and work outside into the open air when it's possible. They encourage the unvaccinated to learn about the building ventilation and take advantage of better ventilated areas if they can. Encourage practicing good personal hygiene, washing your hands often for 20 seconds, using sanitizer, and always covering your mouth and nose if you're coughing or sneezing so you don't spread germs to other people. They also strongly encourage unvaccinated persons to be alert for COVID-19 symptoms and get tested immediately if any appear, and also keep themselves out of public places if that happens, if they suffer symptoms, And even if you're not suffering symptoms, if you're unvaccinated, they encourage getting tested regularly, especially, again, if you're in an area of transmission, which all of us in the state of Michigan are. And a reminder that under Michigan law, Public Act 238 and 339, which were passed in October and December of 2020, they give great legal protections to employees who cannot work for covered COVID-19 reasons, either their own illness, taking care of someone who's ill, being required to quarantine or isolate. All those are protected reasons under the law. And employees who comply with these quarantine or isolation rules and guidelines cannot be discharged, disciplined, or otherwise retaliated against. And we highly, highly recommend staying up to date on the isolation and quarantine rules because they change regularly. It used to be 14 days, now it's down to 10 and 7 days for some circumstances. And we expect to see a lot of retaliation claims arising out of this quickly changing area. I think employers just can't keep up with the changes in the rules. And when that happens, missteps occur that aren't even intentional, but you will be subject to retaliation claims, and your workers are strongly protected under this law. So stay up to date and research before you act, as opposed to think before you act. And now I'm going to pass it on to Courtney, to talk about what everybody really wants to know about, the 100 employee mandate.
Yes, thank you. And I'll just piggyback on one thing that Laura said about the retaliation claims. I will just note anecdotally that I've seen more claims in the past month or so than we had in the prior year. It seems like the attorneys are starting to catch up with the law and starting to file a lot of FMLA claims, a lot of ADA claims, and a lot of retaliation claims. So just want to put everybody on notice to dot your I's and cross your T's if you're taking action against employees in this current environment. So now the big news, the large employer 100+ mandate. So about a week ago, actually it was a week ago exactly, on September 9th, we started to see some press releases about President Biden speaking at 5 o'clock and was going to announce that he had instructed the United States Department of Labor, what we call the DOL, to develop an emergency rule mandating vaccinations for any companies with more than 100 employees. So that automatically got us buzzing and preparing to present this to you today. President Biden came out and he said that he was working with the Department of Labor and had instructed OSHA to issue a particular rule that requires, again, any company with more than 100 employees to be fully vaccinated, i.e. everybody that's working is either vaccinated or are testing at least once per week and demonstrating a negative test before they're allowed to work. So this was huge news, and we're still trying to sort through it. So my presentation today is based significantly in predictions and expectations, because we do not yet have the emergency temporary standard from OSHA. All we've been told is it's coming in coming weeks, so who knows exactly what that means. But the ETS is going to be extremely, extremely important. So when I say ETS, that's emergency temporary standard. We expect that the ETS that's going to be issued by OSHA will cover more than 80 million workers. We also expect that beyond having requirements relative to mandatory vaccination or mandatory testing, that there's going to be requirements regarding paying employees who have to get vaccinated or who miss time from work because they have vaccine-related side effects. So this is big news. What is an ETS? All right, that's the first question that we've been getting. What does this mean? How does this work? The provisions for an ETS are outlined in Section 6 of the OSHA Act. Okay, so generally, to be able to process with an ETS, there are certain requirements that have to be met, and we'll talk about that on the next slide. With an ETS, OSHA does not have to go through the full rulemaking process. Okay, so this is a big deal because it basically allows them to avoid the time periods that we usually see for notice, for public comment, and for public hearing. They get to short circuit the process and issue something in a much more quick fashion. Once issued, the ETS is effective, and then OSHA begins rulemaking for a permanent standard. The ETS is valid until the permanent standard is promulgated, and that has to be within 6 months. So generally what happens is you have an ETS for 6 months, and then it becomes a final rule, and it gets published accordingly. We here in Michigan have the Michigan OSHA, or MyOSHA. So only certain states have a state equivalent to OSHA. And when there's a state plan that's in place, the state plan has 30 days from the issuance of the OSHA ETS to draft and issue its own equally protective standard. So the state can go above what OSHA is doing, but generally they mirror. The state cannot say, okay, we heard what OSHA said, but instead we're going to have different requirements that are less protective for employees. Question, does the Department of Labor have authority to require this? Okay, that's something that I was getting calls about on Friday. Actually, Thursday night, we were getting text messages about how is this going to be happening. There are numerous legal challenges that we expect regarding the scope of authority and the legality of the mandate and anticipated ETS. Several governors have already promised that they're going to try to block the ETS from taking effect in their states. Michigan is not one. Okay, I'm sure I don't need to get into that. We can all expect that this administration is not going to try to block the federal OSHA ETS. So we probably aren't going to get a challenge from our governor, but as Claudia mentioned at the outset, it's not uncommon for multiple states to join together and to file lawsuits in Texas in the Fifth Circuit. The Fifth Circuit is the same circuit where the lawsuits were filed back in, what was that now, 2015, about the white collar salary increase. I'm sure you all remember that fun time period. We scrambled, people were increasing their employees' pay, everybody was freaking out because the salary threshold was going to change dramatically, and then it was enjoined and never happened. So it could happen here, but we don't know yet. But keep an eye on Florida, keep an eye on Texas for lawsuits to be filed there to try to block this. Now, in response to those type of lawsuits, OSHA is probably going to take a couple of positions. One is going to be, we already imposed certain vaccination requirements. Now, I don't think it's analogous, but the argument has been made that there is already an OSHA vaccination requirement for a hepatitis B virus vaccination to any worker that's in an occupational exposure position. But with the hepatitis B virus vaccination, workers can opt out. I don't know how far they're going to get with that argument. The primary argument they're going to make is that they have authority under the OSHA Act to promulgate an ETS in this circumstance. So the key requirements for an ETS are that OSHA determines A, that employees are exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful or from new hazards, and B, that such emergency standard is necessary to protect employees from such danger. So there's a grave danger and this is necessary, meaning there's not an alternative. We haven't found a solution that's worked to date, but this is going to be required to move forward. What do we expect? Okay, so the basic requirement, as I mentioned, is it's a two-pronged approach. You either demonstrate that you're fully vaccinated. If you're not fully vaccinated, then you have to get tested weekly for COVID-19. We don't know what that means in terms of what type of test, rapid, PCR, what's going to be required. We received one question about the rapid test and them being, returning a high rate of false negatives, which is the worst case scenario because you're told you're negative, you go about your business and then it turns out you're actually positive. Now, I've been tested for COVID-19 throughout this pandemic. I have kids in school and they've been close contacts, and I'm sure many of you have dealt with. And I've always been told, don't rely on this rapid. You need to isolate until the PCR results come back, regardless of vaccination status, regardless of symptomology. So OSHA could, in this ETS, say the testing has got to be a PCR test. They also could say it can be any rapid, any PCR as administered by a licensed provider. We don't quite know yet. Some laws, like for example, the Michigan law, PA 339 of 2020 that Laura talked about, it provides for certain types of testing, and rapid is an approved method. So just something to keep in mind. Again, when OSHA issues a standard or MyOSHA where applicable, the company can always go above it. So if the OSHA ETS says you can use rapid or you can use PCR, but you have legitimate concerns about rapid tests and relying on them given your workforce or the demographics or the circumstances at hand, your area of operation, then you can always include a more rigorous testing requirement. We also expect that 100 employees will be counted on a company-wide basis, not by location. Okay, so this is a number, this is an important question that we've been getting. And we got one of the questions in the chat as this presentation has been ongoing. How is the 100 going to be counted? And we all expect that it's going to be company-wide. There's not going to be exclusions for facilities that might be under 100 if they're part of an operation with more than 100. But again, this is a bit of a prognostication. We should know more with the ETS. I think the goal is to cover as many employees as possible. So, reading the tea leaves, it seems that 100 is going to be an umbrella analysis like we've seen in other areas of the law as well. What we don't know is whether this is going to apply to all employees, which would be a little bit weird because that would include people working remotely, people teleworking, people that are not encountering other people in a workplace and therefore don't really fit into that grave danger concern, or only those working in offices or with other employees. What we can tell you is that the more broad the ETS is, the more likely it is to be subject to judicial scrutiny and potentially struck down. So if they, for example, in the ETS say, we're going to require everybody that's working for an employer with 100 or more employees to get vaccinated and test weekly, even if they never leave their household, I think that's going to be subject to some serious judicial problems and likely won't pass muster. So for now, we expect that this is going to be targeted towards individuals who are actually coming to a work site or appearing for in-person work. We expect that it's going to mirror the healthcare ETS, which was passed in June of 2021. The healthcare one is not as broad or as sweeping as this one, but there is a requirement that the company has to pay for the PTO, for the paid time off to get vaccination and possible side effects. That was one thing that President Biden actually said during his announcement as well, is that this is gonna, we're gonna make sure that our people are paid to get this vaccine. We're not gonna have somebody go out to get vaccinated, potentially get sick from it, and then be without pay. So just something to look for moving forward. The testing option is also being viewed as a relatively straightforward way to respond to requests for disability and religious accommodations. The ETS will include an exemption, just as Claudia talked about in some of the other mandates from the outset, for religious and disability accommodations, which we've seen consistently applied since this started and also applies with other type of vaccination requirements. So when there's this testing option, i.e. a fallback option, many commentators think that that's going to help the government survive judicial challenges by saying, we're not forcing employees to put something in their bodies if that might be unconstitutional, or we're not forcing, medical procedures. You have an option, just get tested. If you don't like that, here's the fallback option. And likewise, if you can't get vaccinated because you have a disability or because you have a religious opposition to it based on a sincerely held religious belief, you can get tested. That's a perfectly fine religious accommodation or disability accommodation. So we expect the testing option will be viewed heavily as a totally legitimate, reasonable fallback. This isn't a mandate. It's just something that we're trying to do to increase the herd immunity. The ETS should specify who exactly is going to pay for the testing and how that's going to be provided. For example, there might be tax rebates and things like that that we've seen with the other COVID-19 related employment mandates so far. The administration has taken steps to cut costs with private testing companies, and as noted by Claudia, Medicaid recipients will test for free. So we expect similar structures to be implemented here relative to just the practical cost of this amount of testing and for an indefinite period of time, as far as we know right now. It's unlikely that the ETS will require systematic vaccination reporting or systematic testing data. So what do I mean by that? It's unlikely that you're going to be told you have got to log into OSHA.gov once a week and provide all of this information, or you're going to have to go to MyOSHA and provide the information when MyOSHA issues their mirrored rule. That's not likely, but there will be record keeping requirements. Okay, so you can plan on having to keep clear records demonstrating that you've been in compliance, which means that you have proof of vaccination for all employees that have indicated they're fully vaccinated. And if they're not fully vaccinated and they're working as defined by the Act or the ETS, that you have the testing information. So the record keeping is going to be absolutely critical. And a lot of times the record keeping leads to bigger problems in these type of cases than compliance in the first place. The ETS penalties are expected to be as outlined here. Okay, so serious violations, the $14,000-ish fine, if you've heard that number throw around, and then willful violations, a much larger fine, trying to force companies into compliance here. So again, that's what we expect to come out based on commentary from the administration that we've received to date. The current maximum these are the current maximum penalties. So there's no penalties that are higher than this pursuant to OSHA violations as of now. And again, you know, they're more likely than not going to try to implement the maximums for this due to the nature and tenor of President Biden's comments last week. So the $1 million questions, okay? What do we do now? The first thing, and this is coming from OSHA as well, is to encourage vaccination now. So we talked about whether you could encourage vaccination, whether you could incentivize vaccination, whether you could mandate vaccination. We've been talking about this for well over a year now. I will tell you anecdotally that I did not have any clients rolling out mandatory vaccination policies until maybe the last 5 or 4 months. That it's suddenly started to gain some steam, and we've seen more and more vaccine incentives and mandatory policies lately than we ever did when people were concerned about the scope of this back in 2020 and even in 2021. So it's not unusual for companies at this time, September 16th, 2021, to encourage, incentivize, or mandate vaccination subject to certain exceptions. If you're not going to encourage it, if you're not going to incentivize it such that you obtain information regarding vaccination status that way, you should nevertheless work to get as much information you can about your employees' vaccination status so that you can identify what percentage of your workforce, particular departments, maybe particular locations, where this is going to be a bigger hurdle to stay in compliance with the expected mandate. So a question that I get a lot is, how do we get this information? What can we get? What can we do? Oftentimes we see companies start with sort of a nice option, which is, you know, we're trying to collect information to ensure we're compliant with applicable rules and regulations and the upcoming anticipated ETS. Please advise by no later than September 18th as to whether you are A, fully vaccinated, B, partially vaccinated, or C, unvaccinated with no plans to get vaccinated. Then you sort of collect that information, you store it in the employee's confidential medical file. Okay, so HR can create a spreadsheet or can have a database of this information, but individual medical information has to be kept separate from the personnel file. Okay, the question that we get next after we talk about this is, okay, so say we have 200 employees and 100 respond to this email with their vaccination status, but 100 are refusing to respond. How do we follow up with those? I've generally recommended a nice approach, which is a phone call, an individual email. Hey, you might not have realized this was due. We really need this information. Please respond by September 23rd. You still don't get it? Maybe a stern email at that point. This information is required. You must provide it by the end of the day today. Otherwise, you know, we'll be contacting you individually. And then either a sit-down meeting or a phone call, but some sort of discussion where it's explained, this is not optional. This has got to be provided so that we can make sure that we're compliant with these rules and regulations moving forward. Some employees have either printed out these wild cards that they found online that talk about their constitutional protections and how this is a violation of their bodily freedom. And you might get shown a card that looks absolutely insane. You might get told by an employee that this is their HIPAA information and they have no obligation and they can't give it to you and you can't get it from them. You might be told a whole host of things, okay? So I can just tell you, as we've said this before, but just to confirm, you are not prohibited pursuant to HIPAA from obtaining vaccination information about your employees to maintain and to enforce employment policies, okay? And I expect that the ETS is going to explicitly say that this is not a violation of HIPAA. If you have an employee that is really, really giving you a hard time about this, that is showing you some insane documents or screaming about constitutional violations or the like, then I would tell you to contact one of us or your attorney to walk through it in more detail, because again, what I said at the beginning of my presentation, the number of claims we have seen recently has been steadily increasing, and I mean steadily. So you don't necessarily want to walk into a potential claim because somebody is being difficult. You want to walk through it appropriately. But just so everybody's clear, you can get information about the vaccination status. There's not a broad HIPAA violation that occurs if you're collecting that information. Make sure you're keeping it separate from the personnel file. You should also start looking at testing protocols. So depending on the size of your company, depending on your locations, your geographic locations, what are you going to do in terms of testing? How are you going to do it? Are you going to allow employees to do at-home kits that they're then submitting? Are you going to require testing? For example, if you're getting tested on Friday, such that we'll have the results by the following Monday. The testing protocol should be in place, and it should be very clean, meaning everybody should be told in advance what it is, what it's going to look like, how you're going to operate, where you're going to keep the records. There shouldn't really be much questions about the practicalities of this. What I don't recommend is the wild, wild west, which is just telling employees get tested when and how you want, as long as you give us test results once a week. It's going to be really hard to monitor that, and for human resources to track that information and make sure that you're compliant with your record keeping requirements if you're getting it piecemeal. There's also, secured systems and things like that where you might be able to establish an online method for employees to upload automatically their vaccination or their testing results, so that you're screening it out before they're coming to work on a particular day or throughout the week. You also need to make sure that there's no CBA obligations, collective bargaining agreement obligations that might be applicable in terms of setting up these processes and procedures and requirements. OSHA has come out and they've said that the ETS should not have any impact on collective bargaining. Again, we'll see when that actually gets rolled out. But in terms of your protocols, your policies, the consequences for not complying with the policies, I would make sure that your union, if you're unionized, is buying in and that you guys are on the same page so that there's no surprises when the policies are rolled out. The next thing is positive results. Okay, so this is a whole nother ball of wax, because there are many times, I'm sure, that we've all worked in workplaces with asymptomatic positive employees that had no symptoms, no exposure that they were aware of, no way to know that they were COVID positive. You are going to find that there are going to be a higher incidence of positive results, and you're going to have more people excluded from the workplace because of this. Because there probably were people that are vaccinated or not that were capable of working without even realizing they were infected by the disease. So we need to make sure that you're up to date. You're looking at your local health department guidelines in terms of isolation and quarantine orders. The Michigan law in terms of prohibiting retaliation against people from who miss work due to COVID-related reasons refers back to the CDC guidelines in terms of how much time do they need off work. The CDC guidelines refers to local public health guidelines. So if you have an office in Oakland County, an office in Kent County, an office up in Petoskey by Laura, you need to have a map and have the local health guidelines pulled up so you know, okay, this is what happens if we have a positive in Kent. This is what happens if we have a positive in Oakland. And you should do that now. And then we'll alert you if there's any changes to those guidelines, something to be monitoring individually as well. But that way there's no surprises and everybody understands, this is the process we have to follow. What happens next and when will we know more? Hopefully within 2 weeks, unclear as of now. The acting administrator did a conference call on the 10th and he said, coming in the quote unquote coming weeks, which is lovely, super specific. We're hoping by the end of September at the latest. The ETS will address many of the questions posed. Again, we expect it to closely mirror what we talked about today. If there's anything shockingly different, we will let you know as soon as we see it. We are also planning on follow-up programming as needed. So as soon as that ETS comes out, you can look to us to keep you updated about the specifics and any unexpected provisions, and also any practical solutions that we've seen work well in light of this changing environment. So that's the canned presentation. And now we have some questions. So before I get to the survey stuff, let me go through this chat real quick and let me actually also make sure nobody else has asked any questions or doesn't have their hand up. Just run through this. Okay. Miss anybody? All right. I don't think anybody here has their hand up, but there's some questions here in this chat. So Claudia's done a good job sort of going through this and answering some of the questions, which is really helpful. So one of the things was asking about the just housekeeping, the slide deck, the presentation. It will be available to the attendees. We're going to email it out and hopefully have it posted to the website after the presentation is completed, so that the PowerPoint is available. A question that we get a lot: can you ask for validation of exposure or positive test results to justify the absence? As Claudia mentioned, you can ask for the test results, and what kind of validation. So with the validation, usually the best we can get is the employee confirming in an email, the information I've provided here is true and accurate to the best of my knowledge. And this is the situation, and then you have them confirmed in writing. That's usually the most I would do, or have a form where they sign off on it, an actual physical signature. But unfortunately, there's not much more you can do with that. I'm making sure that Claudia's answered all of these questions in here. Yeah, one of the questions is about working remote and not vaccinated. Do they still have to test weekly? Hopefully I addressed that with my section. So FMLA. So, Claudia talked about this, but Claudia, can you explain this in a little bit more detail? The question related to actions from time of testing for return to work. Is this FMLA qualified? Is there federal pay? Like, how does this all bleed together? Can you touch on that for a minute?
Very tricky. That's how it links. No, actually, family medical leave could apply. It's a separate test. You have to run through every single factor of the test, just like you normally would, to see whether or not they qualify. Most of the time, COVID will not qualify unless they're literally incapacitated. Just testing positive doesn't mean that they're incapacitated and for more than 3 days. So you have to run through the test. And as far as pay goes, if there are certain healthcare workers, emergency responders, they may qualify for the pay under the emergency rule that OSHA put out for the healthcare workers. You may have to pay them. For other employees, there's no more pay. It's possible they'll qualify for workers' comp. For certain healthcare workers, again, there's sort of a presumption that they caught it at work. So you just take the information, turn it over to your carrier. For other employees, they'll say, I think I caught it at work. And it's like, okay, so just turn it over. Why do you think that? Write out your statement, turn it over to the insurance carrier, stay out of the claim. It's up to them to decide. But there isn't any longer any COVID pay per se, like you were doing last year with the, 2/3 up to $200 or $1,400, whatever the circumstances were. So don't worry about that, but you should always allow them access to their paid time off banks.
Yeah, I agree with that. We get a lot of questions too about how 100 employees is going to be calculated. Okay, so that will be specifically defined by the ETS. I can tell you that generally they calculate as broad as possible to cover as many companies as possible. So if you look at the definition of covered employer, for example, under the FFCRA and some of the other recent legislation that is being enforced and reviewed by the DOL, that's probably a good bet. And generally, we're going to look at it as broad as possible. There might be exclusions for certain type of employees, but as to like temporary workers, contract staff, I expect they're going to cover it, because if there are employees that are coming to your premises and they want those employees to be vaccinated. And if you only have 50 regular W-2 employees, but you work with a staffing company such that your facilities typically have more than 100 people, I expect that they're likewise going to want those people covered. So I don't think there's going to be a lot of ways that we can get around the 100 employee threshold by saying, well, this is a different division, or this is a different location, or we work with a staffing company. I would look for there to be very broad coverage here. I don't know if Claudia agrees, but that's what I've heard, and that's my expectation.
Yeah. They've been on your payroll, they count.
Yeah. And then another question about antibodies. So we've heard this a lot as well. Like, well, I had COVID, so I'm not getting vaccinated because my antibodies are 10 times more powerful than the vaccination, right? There's a lot of information like that out there on the internet. I don't expect there to be any exclusion. And this is why. It's because there's concern that the antibodies diminish over time, in that the antibodies, they're not as easy to track, right? So long story short, I don't think there's going to be any exclusion for the antibodies, and I don't think OSHA or MyOSHA is going to care about antibodies. I think they're going to enforce this quite strictly as vaccine or test, regardless of your prior COVID-19 diagnoses. And then the question is, one of the questions is about, shouldn't everyone get tested weekly since the vaccinated people that can still get sick? And talking about breakthrough cases. I mean, we've seen more vaccinated people have breakthrough cases. This is the concept that I believe they're going with, okay? To get an ETS, they have to demonstrate there's a grave danger. What we've seen with the breakthrough cases is that a lot of the people that are vaccinated and get COVID, they're not in grave danger. The hospitalization rate for those people is extremely low, and the death rate is extremely low. So the people that are in grave danger are the people that are not vaccinated, which is why we're trying to push to have those people vaccinated. So it's not necessarily just about, preventing the spread of COVID. It's preventing it from having a grave impact on an employee. And then on that, again, there's a lot of questions about the 100 employee threshold. So we'll provide more information about that once we know. If you look for now, if you're trying to predict this, I would look at the definition as explained in the FFCRA and in that FAQ breakdown from the DOL, because they tend to borrow from other laws when they're reviewing this. Claudia, one of the questions that's been coming up is what type of religious exemptions are going to be allowed here? Like, what does that mean? What if I come in and I tell you that, I'm praying to the Church of Taylor Swift, which some days I do. Can I get a sincerely held religious exemption for that?
Courtney, that's just wrong. But actually, it just has to be a firmly held, sincere belief. You have to analyze it under Title VII, the way you always have for religious exemptions, to like rules for piercings and things like that, or certain days off. So it just depends. I've actually prepared a form that I've given to some clients who've requested it, that makes it a little bit harder for them to lie about their sincerely held beliefs. So for example, I asked them, have you had the flu vaccination in the past? And if so, please explain as part of your explanation of your firmly held belief, what has changed. So see if they can get around that. Because if it's just vaccinations in general and they've always had, they can say, well, this is a new firmly held sincere belief. I mean, they can say something like that. But I also make them sign underneath a statement that says, I attest under criminal penalties of perjury that the above information is truthful, and I acknowledge that providing false information is grounds for immediate discharge. So they may at least pause, but a lot of them will think, how are they going to prove it? So you never know, and like I said, I'll come up with something wacky, just like Courtney said, the church of who is that again? The crazy one?
Taylor Swift.
Taylor Swift, of course. Sorry, wasn't a fan, so I could.
No worries. No, yeah. I've gotten a lot of questions about the religious exemptions. I haven't seen many, practically speaking. Yeah. The vast majority of exemptions that have come in have been medical. And a lot of times this is what we get. I can't get the vaccine because my doctor said I can't. And then we say, okay, have your doctor give us a note that confirms that, and or give them a questionnaire relative to the ADA analysis, and nothing comes back. And I will tell you, again, anecdotally, I was at my kid's pediatrician, and she mentioned to me that she's been getting asked so much for waivers and for notes, and they won't give them. Like, I'm not just giving them. I'm not just giving these like broad waivers, these broad notes. But to the concept that there's fear that doctors are out there doing that. Some might. But I would say out of every 10 cases where somebody says, I can't get this vaccine because I have a medical condition, 8 of the 10, there's nothing forthcoming and the exemption is not at issue. So just something to think about.
Courtney and Claudia, this is Laura. I have dealt with the religious exemption in the past over flu vaccines. And there, you know, creative employees may find it. There are sites out there on the internet which use all the buzzwords that you have to use to qualify for a religious exemption. And I mean, I found sites that someone had copied word for word to qualify them for the religious exemption. So you can probably expect that you will see some if they can't get the medical.
I had one that had her sister write a note who was, and it was the funniest thing because she was a formerly Hindu spiritual guidance leader who has watched her sister go on the spiritual walk, who then became Muslim and then Southern Baptist. And it was like, and now she can't, you know, she can't work on Sundays. It was like, what? So you'll get some, if nothing else, it'll be amusing. So
Yeah, that's true. And then there's another question here about required to pay the PTO. Do they have to go above and beyond their bank? I expect to be similar to the FFCRA, which means you get a tax rebate, but you cannot make them use their bank first. So under that law, as I'm sure you know, the EPSL, you couldn't force them to use PTO before they're eligible for the emergency paid sick leave. I expect, and based on some comments from the administrator, that that's what we're going to see structured with this as well.
yeah, so you may end up having to give them a day and a half off or 2 days off or something for the symptoms, but at
Right,
least,
and then
but at least when they're vaccinated, it may cut down on your need to give them 2 weeks off. So
that's sort of the concept, and that's why I also expect them to be some sort of a tax rebate or credit or some sort of a give to private employers, especially those with, you know, a significant number of employees. I mean, that PTO bill could be quite hefty. All right, so then who pays for the weekly testing? That's going to be addressed by the ETS. So, you know, the expectation probably is that there's going to be some employer costs with maybe, again, shared credits, rebates, things like that, government assistance. The government is trying to make the testing as cheap and as widely available as possible, and is implementing a bunch of programs to try to address those costs. We shall see. I doubt that it's going to be employee 100%. I just don't think that that's realistic.
and employers, if you're interested, you know, you can reach out to some of the local federally qualified health clinics, and they may be able to send one of their medical assistants or RNs out once a week, Monday mornings or something, to run through and give everybody their testing or something. Of course, there'd be a charge for it, which would help the nonprofit as well. But, you know, there may be a way of doing this more efficiently.
Yeah, I expect there to be a lot of that, a lot of on-site testing, especially for companies that have a larger population of employees that are not vaccinated. We saw a lot of just on-site COVID testing generally when the case numbers were really rising rapidly. So that's something to look for. If you do the first step in the analysis, one of the things we talked about, which is figure out how many people do we have now that are unvaccinated, you probably have a better idea as to whether you're going to need to implement a measure like that, or if you're just going to be dealing with a handful of individuals that need to provide these testing results. All right, I think that, one last thing, the best source to review the ETS updates. I will tell you that I generally don't trust anything unless it's got a .gov from it, because a lot of times we hear people pontificating or summarizing things incorrectly. So we should get the ETS within the coming weeks. And once we get it, we will condense it and identify it and cite to specific provisions in the ETS. So you can expect that to come directly from Plunkett Cooney. In the interim, if you're looking for updates, if you're looking for predictions, look for things where it says that the acting administrator of OSHA is saying X, Y, or Z. So right now, the acting administrator of OSHA is James Frederick. So if you see something that says James Frederick indicated X, or the Department of Labor is acting administrator indicated X, like look for a government authority, not just a person on the inside with the no. If you were going to actually start making decisions, that the ETS, coming weeks, let's keep our fingers crossed it's here before the end of September, and then we will condense the key requirements for you and make sure everybody knows the applicable deadlines and what to prioritize moving forward.
Yeah, and remember, once the ETS comes out, take a breath, give it a day. and watch for the lawsuits to get
Yeah.
filed and everything to be put on hold. Because remember, you all ramped up to change who was going to be a, an exempt salaried employee a few years back, and notified employees only to find out that the new white collar regulations weren't going into effect. So just take a breath, and you'll have time to ramp up and see if it gets challenged and quashed first.
Yeah, that was a fun time in all of our lives.
I loved it. What's not to love?
Oh my gosh. All right. Well, that's it for us. When you close out of this Zoom, you're going to get a survey. We, as always, ask people to provide the survey results so we can make our programs as tailored to your needs as possible. The presentation is going to be online, so don't worry about getting slide decks. If you have any issues accessing it, you can email me directly. We encourage everybody to view our blog. There's a lot of good information on there. The updates to the ETS is going to be a rapid report. That's something that you're not going to have to like check the blog to see what's going on with that. We will distribute that to you, and we will likely be doing a follow-up webinar as well. So please keep your eyes peeled for that. Everybody have a really good day. We're here for you. We know what your lives are like because ours are like that too. So don't hesitate to text, call, email. We're here for you and to keep you as updated as we possibly can. So thank you, everyone.
Bye.